A viewer writes in and asks, I am a 68-year-old widow and I own a home in Ontario. I have 2 sons and 1 daughter. I want to distribute my house 50-50 between my 2 sons when I pass away. I have a life insurance policy on which I've made my daughter the sole beneficiary. One of my sons is married. The other son is not married and he also owns an income property in Nova Scotia. I would like to add my sons onto the title of my home to avoid probate when I pass away, but I'm concerned about the tax implications for me and for my sons. Is this a good idea? In this video, we're going to talk about probate for this viewer and the risks and trade-offs that come along with adding your kids' names to the ownership of your home for estate planning purposes. And if we haven't met yet, my name is Mark Walhout, and I created this channel to share ideas and concepts that I'm using to help people with retirement every day. If you want to get more videos like these, consider subscribing to the channel and hit the bell icon so that you're alerted when new videos are posted. So ultimately, whenever somebody is thinking about adding their children's names to title for their assets to avoid probate, it comes down to a question of, is the juice worth the squeeze? That's kind of an old expression, but I think that this is ultimately the right frame to look at the trade-offs that come along with this strategy. So what is the juice that we're trying to get from this type of strategy? It is to avoid probate. And in the province of Ontario, assuming that this viewer's house is worth around $1 million, they're looking at probate of $14,250 when this house drops into their estate and transfers to their heirs, or 1.5% of the value of the estate above $50,000. So that is the amount that this viewer appears to be wanting to avoid. It doesn't sound like from the question that this is meant to be an outright gift. This is really meant to be an estate planning strategy. So that's the juice. That's what they're trying to achieve with this strategy. So let's talk about some of the risks. We're going to dwell a lot on taxes because this does become a big part of the risk, as well as the actual estate planning implications, but we'll start with taxes. So there may be a situation in this strategy where taxes may be payable. In most cases, when title changes on a piece of property, the ownership changes, and that's considered a disposition for tax purposes in the eyes of the CRA. Our viewer would need to report a capital gain on their tax return for the portion of the house that is changing hands. So assuming that they're going to give 2/3 of this house to their sons, then 2/3, it would show up as a disposition of 2/3 of the property. They would need to report that on their tax return. It's possible that the disposition of this 2/3 of the property would be sheltered by the principal residence exemption if it is this viewer's only property and they ordinarily inhabit it throughout the year or throughout the time that they've owned it. But from that point onward, though, the gains in value for the portion that has been transferred to the sons may eventually be subject to tax down the road when they sell the home, if they don't ordinarily inhabit the home with you, if it's not their principal residence. However, if there's no consideration given to you, the viewer, for the ownership transfer, and if the transfer is not an outright gift, it's possible that this change of ownership would not constitute a taxable disposition at the time of the change in ownership. And this comes down to a concept that's called the difference between legal title on paper and actual beneficial ownership. If the viewer who asks the question simply adds her sons to title for no consideration, meaning no money changes hands, the sons don't purchase their share of the property from the mom, and if it's not an outright gift, it's not documented, and in behavior of the sons and of the mother, it's not treated as a gift, then the CRA would look at that and say, well, this is only being done as a matter of convenience. The sons really have no skin in the game. It's not clearly an outright gift. And they would look at that transaction and say there has been no change in beneficial ownership. And the original or the beneficial ownership would stay with the mom. And in the case where there's simply a legal ownership change, there would not be a taxable disposition at the time of that change. If, however, beneficial ownership did change, meaning that mom gifted 2/3 of the property to the sons, or if the sons bought their share from the mother in that transaction, then there would be a taxable disposition. There would be a capital gain that would need to be reported on the tax return. So it just really comes down to, what is the nature of this ownership change? Does money change hands? Is this an outright gift? Now, these questions become very murky, very muddy, very quickly. So if you're considering a strategy like this, I highly recommend speaking to your financial advisor as well as your lawyer and your attorney and talk about what you're trying to achieve and determine, is there a proper way to do this that suits sort of your desires, your intended outcomes, and avoid some of the risks as it relates to taxes that you'd want to avoid. Now let's talk about some of the other risks that can go along with this strategy. And the next big risk in my mind is the loss of control, or the potential loss of control that the viewer would encounter if they added their sons to the title of the property. So once the viewer adds their sons to the title of the property, they effectively need to get sign off from those other two sons in order to do anything with the property, to either borrow against it or eventually sell it. Now, at the time that you might be considering this strategy, you might say, hey, everybody's on the same page. We all agree that this house is going to be kept in the family and that it will eventually transfer to the two sons. But life can change, relationships can change, and the necessity to get the sons to sign off on future transactions with respect to that house may become difficult, and it may become a very serious point of contention and difficulty down the road. So that's the next big risk with a strategy like this. The next risk is legal exposure. Once the sons go on title of the property, the home becomes exposed to your son's creditors. So you mentioned that one of your sons is married. If he and his spouse divorce, the house, if he's now on title, can become part of family property, and there might be a claim for division of assets that goes against that house if your son were to divorce with his spouse. Another example, if your sons or one of your sons runs into financial difficulties, they go through a bankruptcy, that asset can be now made available to creditors to settle their financial affairs if they are on title. And that is an exposure that doesn't exist if you solely are on title and the sons are not added. The next risk is equalization. And you mentioned in your question that you have a life insurance policy that's going to go to your daughter when you pass away. But it's possible that the two 50% shares of the house and the life insurance policy are different values. And that might be your intention. It may be your intention that the life insurance proceeds are going to be worth a different amount at your passing as the shares of the house are going to be. But that might end up being a point of contention down the road if that wasn't your intention. If, let's say, the life insurance policy is for $150,000, $200,000. If the house is worth $1 million, that means two 50% shares of $1 million or $500,000 for each of the sons. That's a lot more than the amount of the life insurance policy that's going to your daughter. So that could eventually become an issue. And the final risk with a strategy like this is that the idea of avoiding probate may not actually work. Remember earlier we talked about beneficial ownership and legal ownership? If beneficial ownership doesn't pass to the sons, meaning that if the house is not given as an outright gift, or if there's no consideration provided by the sons to the mom to purchase the home, the court may deem that the title that the sons hold on the property is effectively a trust, and that the sons are simply holding the house in trust for the benefit or on behalf of the estate. And they may deem that even though the sons are on title, that the house would become an estate asset and it would be subject to probate. So you might go through all this work with your lawyer to avoid probate, and you will encounter all these other risks that we talked about: loss of control, exposure to creditors, and effectively at the end of the day, it may not even work if the court deems that the house should actually be an estate asset, even though legal title has changed. So is our viewer out of luck? I don't think so. The viewer might consider using something called an alter ego trust. And a trust can achieve a lot of the things that the viewer is looking to achieve. It can avoid probate fees. The viewer can continue to maintain control along with her trustees. There would be protection from legal claims from family and their creditors. Now, setting up trusts is a new layer of complexity. You'd certainly want to work with a qualified estate attorney before you start to enter into trust agreements. But this is a great example of where there are better legal structures available to the viewer to achieve her aims that, yes, may require a bit more work up front, but will allow her to avoid a lot of the potential risks and pitfalls along the way. But this planning is good. I really love getting these questions. It is a common question. Adding adult children to title of homes is a very popular strategy. I do receive a lot of questions about it. So I'm very glad that you wrote in with this question, and I appreciated the opportunity to answer it. But certainly if you're thinking about doing something like this, consider speaking with your financial planner, with your estate planning attorney and accountant, and just talk about what your aims are and see what is the most efficient, balanced approach that you can take that allows you to achieve what you're looking to do with as little risk as possible. Thanks for watching this video all the way to the end. I'll link to a couple of previous videos that I did on the topic of adding your kids to assets for estate planning purposes. If you have any questions or comments, please leave them below. Thanks again for watching, and I'll speak with you soon. Take care.